We continue to see firsts in the Second Amendment advocacy world, as in an unprecedented way, the Federal Department of Justice files an amicus brief in favor of the Second Amendment. This is Wolford v. Lopez. Let's talk about it. Hey everybody, welcome back to the channel. Today we are still on the federal Second Amendment news cycle here because some interesting things have been happening, and to talk us through that with the federal DOJ, we have brought back the attorney from Michel and Associates. His name is Kostas Moros. Kostas, thanks for being back with us today.
Great to be on again. Thanks, Kevin.
Absolutely. And guys, before we get into this today, please be sure to like, share, and subscribe to these videos. It really helps get the message as far and wide as possible. At the end of the day, through Second Amendment litigation and legislative efforts, we are trying to move that Second Amendment ball in the right direction, as we have been since the last election cycle. And it has continued to kind of pick up speed. So, Kostas, let's jump into this. First, guys, here I've got a couple things that I want to read for you today. The first is coming from Second Amendment News. It's an article titled DOJ Files Historical Amicus Brief in Support of the Second Amendment. Jacob, if you could pull that up for me. It reads like this, you guys. With no fanfare or press announcement, the United States Department of Justice filed an amicus brief strongly supporting the Second Amendment and possibly hinting at a long-term position that the DOJ is taking under the Trump-appointed Attorney General Pam Bondi. On May 1st, the DOJ filed an amicus brief in support of petitioners in the case of Wolford v. Lopez. And guys, if Wolford v. Lopez sounds familiar to you, I know I said that this was a federal thing, but the May v. Bonta case on Senate Bill 2's sensitive places was heard in the Ninth Circuit with Wolford v. Bonta. We've had a few videos on that. We saw the parts that were enjoined, the parts that weren't, and some of that is what we're going to talk about today. So, getting back into it, which is being appealed to the Supreme Court from the Ninth Circuit Court of Appeals. The brief is historical because it is the first time under this administration that the DOJ has formally indicated, in writing nonetheless, its position on the Second Amendment outside of the executive order directed towards it by President Trump. In quotes, this is a major about-face from a federal government that regularly advocated for gun control before the Supreme Court just a few short months ago. Even more significantly, this brief signals that the DOJ is scrutinizing the deep blue states that are flagrantly trampling the Second Amendment and is serious about treating gun rights as civil rights. If the DOJ follows through on all of this, it could mean that a significant gains for gun rights nationwide, said Hannah Hill, Vice President of National Foundation for Gun Rights, the legal arm of the National Association for Gun Rights. So that is from the article. I did also want to share with you guys a little bit from the amicus brief itself. Jacob, if you could pull that up really quick. The amicus brief reads like this. From the earliest days of the Republic, individuals have been free to carry firearms on private property unless the property owner directs otherwise. And in the New York State Rifle and Pistol Association v. Bruen, this court confirmed that restrictions on carrying firearms for lawful purposes such as self-defense violate the Second Amendment unless they fit within a discernible historical tradition. Yet after Bruen, 5 states, including Hawaii, inverted the long-standing presumption and enacted a novel default rule under which individuals may carry firearms on private property only if the owner provides express authorization, such as by posting a conspicuous sign allowing guns. Violations constitute misdemeanors punishable by up to a year in prison because most property owners do not post signs either allowing or forbidding guns. Hawaii's default rule functions as a near complete ban on public carry. A person carrying a handgun for self-defense commits a crime by entering a mall, a gas station, a convenience store, a supermarket, a restaurant, a coffee shop, or even a parking lot. Yet in the decision below, the Ninth Circuit held that rule against the Second Amendment challenge. This decision warrants this court's review. Hawaii's novel default rule defies, indeed effectively nullifies, the general right to publicly carry arms that Bruen recognized. So that was kind of a lot, but Holy smokes, I didn't want to not read it because the Department of Justice is talking to the Supreme Court, telling them to reinstitute Second Amendment rights for Americans. So, holy smokes. But, Kostas, you got a little bit of nostalgia here with the Wolford v. Lopez case because we worked so closely with it in the May case. And since then, we've got this unprecedented in sentiment, at least I would say. I'm curious, though, CRPA filed an amicus brief here. So we're talking about a DOJ amicus brief. Lots of people file amicus briefs. Is there any more weight on the Federal Department of Justice passing one of these amicus briefs on to the Supreme Court than anybody else?
Oh, yeah. So first of all, the article you read from kind of undersold it. This isn't just the first time the Trump administration has filed an amicus brief in support of the Second Amendment. It's the first time the federal government, period, has ever filed an amicus brief in support of the Second Amendment. The one in Heller that the Bush administration did was very wishy-washy. It acknowledged that the Second Amendment is an individual right, but then implied that the handgun ban might still survive under intermediate scrutiny, so they should remand it back to the district court. Or the appeals court. So this is the first time we got a full-throated endorsement of a Second Amendment right from the US DOJ. And now to actually answer your question, yes, it does matter a lot that the US Department of Justice, the Solicitor General, is asking for cert. The DOJ only very rarely does amicus briefs in matters that it is not directly involved in or directly affected by. For them to step in now and file this brief in a case about a Hawaii law is incredible. And I don't know if it guarantees the court will grant cert, but it historically, when the U.S. government shows interest in something, the Supreme Court is far more likely to grant cert. This is still an interlocutory case, so that may still stop cert. However, maybe this will increase the odds of doing something we suggested in our amicus brief. We told the Supreme Court in our conclusion, look, if you don't want to grant this because it's interlocutory, fine, but why don't you reimpose the district court's injunction while the case proceeds to final judgment? So basically, enjoin the vampire rule again while this proceeds to final judgment. So maybe the U.S. DOJ's involvement here, even if the Supreme Court doesn't grant cert, will at least get them to do that much, to give Hawaiians some relief while they wait for that final judgment.
Yeah, speaking about the vampire rule, we saw Wolford and May get argued, and we saw the ruling on both of those lawsuits from the Ninth Circuit. It wasn't just the vampire rule. It was a lot of things. Hawaii and California both really didn't like SCOTUS's take on Kerry with the Bruen decision when it came out. So they immediately got their legislative teams together to pass legislation on sensitive places. A lot of them were the same, which is why the Ninth Circuit heard them together in the first place. But you did kind of have the vampire rule sticking out as something that was still enforceable in Hawaii and not enforceable here in California, according to the Ninth Circuit's ruling. I'm sort of curious, though. This amicus brief is all about the vampire rule. Well, first of all, can you explain what the vampire rule is in the first place? And I'm sort of curious, because this amicus brief is all about the vampire rule, if this does get taken by SCOTUS, is that all that they're going to hear about, or are they going to talk about sensitive places altogether?
So it's a good question. So the petition, and probably because it's an interlocutory posture, they were conservative in what they're asking for. They didn't ask for the entire Wolford case to be reviewed. They asked for two things. They asked for the vampire rule to be reversed, and they asked for the Supreme Court to decide finally whether 1791 and the years around it or 1868 and that era are the most relevant time period. So, our side has always been that the founding era is what matters most, and Reconstruction era 19th century evidence only matters insofar as it confirms what came before. So you can't have all these new restrictions that started to pop up in the late 19th century, decide the scope of the Second Amendment. But the government, state and federal government, always want to use the 19th century laws and treat them as more important, because then it makes their job a little bit easier, because there's more laws to compare to, because there was more gun control laws in the 19th century than there were in 1791. So the Wolford petition asked for that second question as well. Now, tellingly, I shouldn't say curiously, tellingly, the US DOJ's brief only supports Wolford for the first question. They don't talk about the second question. And I think, it is great to have these new allies, and we're very grateful that the US DOJ is finally showing a positive interest in the Second Amendment. However, there probably are limits to that, and they still are the federal government, and they still have all these other federal gun laws that they do want to keep enforcing. So that's probably why they don't want to go so far as to endorse the whole 1791 argument here now. But still, you don't look gift horse in the mouth, so we'll take what we can get.
Well, having said that, if all that they're going to do is view the vampire rule, let's bring it back to California here a little bit. Is there any avenue, since it is one of the part of the question that they asked, is there any avenue here where the Supreme Court takes this case, hears those two questions, and it affects May v. Bonta in a positive way?
Sure, just because the US DOJ didn't ask them to review the second question, it doesn't mean the Supreme Court won't. Now, is it likely they'll go to, maybe not, maybe they'll just limit it to what the US DOJ asked for, or they might just deny cert entirely despite the amicus. That's still a possibility, unfortunately. But let's say they do review the vampire rule. When they do that analysis, they're still going to drop hints and helpful sites for us about that may affect our case going forward. So if they start talking about, for example, Hawaii cites this racist black code law from 1865 to, that was kind of similar, but it was only passed to harass newly freedmen, right? It wasn't enforced against everyone else. So if they say and these sorts of laws are inappropriate because they're outliers and this and that, well, we can then use that criticism against other laws that California has used, historical laws that have similar origins or are similarly outliers and not that common. So the analysis matters a lot. How they get to the answer matters a lot. So hopefully they do grant cert and give us that tool.
Well, that could lead to a lot of positive outcomes for the Second Amendment advocacy group. If you do end up defining the scope like that, that could affect a lot more cases than just this one. But so we're kind of living in a time here where every Monday or so, you wake up in the morning, you hold your breath, and then you look at the order list for SCOTUS, and then you exhale a huge sigh of frustration. You've got the Snope case that I think has been relisted, 13, 14, or 15 times now. You've got which is up on judgment, but then you've got the Ocean State tactical case, which is also up on interlocutory appeal. I understand that, this is the Department of Justice who is essentially asking the Supreme Court if they would take this case. How do you see this moving forward? Is it just something that we have to watch on every order list day? What's the timeline that you could perceive here?
Well, if you read the full brief in Wolford, interestingly, they also say in there that the Supreme Court should answer a lot more Second Amendment questions, including hardware questions. And that was kind of, it was too late for them to do an amicus brief in Snope because that deadline passed by the time the new administration took office. So they can, and we hope they will, do an amicus brief on Duncan when that cert petition gets filed. But it is interesting that they did manage to squeeze that into the brief. And will the Supreme Court notice, and maybe that helps persuade them to finally grant Snope? I hope so. It is true that, with realists, and this is kind of the tea leaf reading game on Snope, with realists, one or two are good. Once you get more than two, it's usually a bad sign that someone's writing a dissent. However, once you get to 8, 9, 10, 11, that's your odds start to go back up after falling because that's too long for just a dissent. Now, I don't want to get everyone's hopes up. It's totally possible they get denied with a dissent. Maybe there's some protracted negotiation going on and it fails, and then Thomas writes a dissent from denial of cert. So I don't want to get everyone's hopes up, but we are in the ball game. So yes, I am going to keep waking up. I had a day off today, but most Mondays when there's an orders list, we're going to have to just keep checking. The record on relists is 23. Snope is at 14. I hope we don't break the record and have to wait that much longer to find out. But we'll see. Either they'll grant it, they'll deny it, or they could issue a per curiam. And then we'd have to see what that per curiam is. Would it be a dispositive ruling, or would it be a punt in which they say, hey, Fourth Circuit, you did this wrong and this wrong, try again, which would just delay everything some more. I guess it's better than a denial, but yeah.
Well, certainly a lot of positivity that could come back, and I was looking at the stats, and they looked a little bit dire, but it's good to hear that it seems like as it keeps getting relisted, the opportunities increase there. So definitely something to look forward to. Kostas, I appreciate, as always, the time, the knowledge, and the wisdom. Thank you very much for coming on today.
Thanks as always, Kevin.
Absolutely. And guys, if you like videos like this, you want to see more, please, as always, be sure to like, share, and subscribe to the videos. If you're not already a CRPA member, even if you're not living in the state of California, you can still contribute at Ground Zero here, where the worst of the worst Second Amendment laws are created and then exported to the nation. This is no secret. If you want to see them stopped here, if you want to have an interest in stopping them here, go ahead and hit that link. Become a member today. Every cent helps and every cent counts. Thanks again, guys. We'll see you on the next one.